This is Washington House, George Washington House here on 42nd, which are across the street next to 56 Law Firm, and Mr. Chadwick and Worth, and also the Schultz Law Firm. And this is on the services they provide here at the George Washington House. As you can see, we got an update planning for understanding the system, and the month featured planning and digital access. This is the estate plan will provide traditional assets like a home, jewelry, cash, or bank accounts. This is the months featured for January 7th, 2020. And this is the traditional assets: home, jewelry, cash, bank accounts, checking accounts, saving accounts, seed, bear bonds, bear claim, bear clones. And this is many people unaware, however, to the extent of their digital assets created by used in daily life, as well what happens to those digital assets at death. Individuals increasingly rely on online accounts, own assets. They may exist only on internet. These digital assets may include financial accounts, internet-based business, social media accounts, photographs, documents, and other digital files. Each of these assets may require different user and password to access and manage. Is the estate planning attorney's responsibility to show clients why it is important to plan a digital asset or dismiss this inconceivable individual dies or becomes incapacitated? Critical digital assets may be difficult or impossible for anyone other than account holder or owner to control. Practical Law Trust Estates update resources to help counsel property address the digital assets, client's estates plan, including practice note, planning for digital access, standard clause, digital asset clause for will or trust, standard clause, digital asset clause, or financial power of attorney. Now, January featured a resource understanding grantor retained annuity trusts. This month, Practical Law of Trust Estates highlights practice note understanding grantor retaining annuity trusts, contributed by Kier, Rucker, Perry, White, and Case LLP. When property structured and funded as a grantor retained annuity trust grant, can be powerful estate freeze type planning toll wealthy individuals seeking the reduced element in the position of gift estate taxes. Transfer their assets, simply term grant designed to freeze or transfer tax value of assets contributed to the contribution date, so they can subsequently appreciate these assets to be transferred from free transfer tax and designated reminder. Now, appreciation meaningful during the trust term. Hallmark features. Here it is, this one. Transfer to free or transfer tax designated reminder beneficiaries. To facilitate this result, typically funded with assets likely appreciate meaningful during a trust term. Hallmark features the grantor's retention of the right to receive a specified annuity amount each year for the term of years. The present value of this annuity stream offsets the value of the grantor's initial gift of the grant, thereby reducing the gift tax payable, even eliminating it entirely, as long as the grantor, in fact, survives until the end of the trust term. Any assets remaining to grantors, finally annuity of the paid, will pass free transfer tax designated reminder beneficiaries. Now, grant is likely the most advantageous for those who is likely to die with a gross estate that meaningfully exceeds the individual anticipation estate tax credit, taking into account prior gifts, spousal probability, and charitable deduction as appropriate. Owns one more particular asset, portfolio assets that have meaningful probability of sustainable, appreciating, and foreseeable future. New content. Trust States has published the following of these resources. Practice Note, Estate Planning Technology Interpreters, Alpreneurs. Practice Note, Probate in Oregon. Practice Note, Ethics, Estate Planning Conflicts and Interests as Joint Representative. Practice Note, Ethics, Estate Planning Attorney Competency. Practice Note, Ethics, Estate Planning Client Capacity to Plan. Practice Note, Ethics, Estate Planning Duty Confidentially. Confidential information. Ethics in estate planning, managing attorney-client relationship. Practice Note, Ethics planning, non-clients paying attorney fees. Practice Note, Ethics planning, estate planning, attorney, beneficiary or fiduciary. Standard document, revocable joints, trust, and married couple. Basic standard documents, letter client, draft, revocable trust agreement with disclaimer. This is U.S. Court of Appeals of the Fifth Circuit. This is the docket numbers 17-60212. And Mrs. Ajmer Singh Nijjar and Cimaron 593 Bank of Party and Bottom will have this circumstance. As you can see, the services they provide here at the George Washington House. As you can see, a beautiful day here in Alfredo, Washington. And this is C Street, the courthouse, Melissa McKnight, accessor, and also Larissa Perez and Kirk Slinger, Mr. Human Resources, and he is the service rep. He's the fully qualified coordinator, human resource coordinator as in the director, the human resource director. And this is the Freda Courthouse and George Washington House, which is right across the street. Mr. Chadwick is on law firm right next door, and then his services with the Daniel Garth, which is on Broadway. That's the private counsel, and also the private counsel, they have Mr. McKinnon Law Firm. He does the law firm right here in Pioneer Way, right next to Rhonda Kaiser Freedom, and they also have the law firm Stephen H. Sackman in Othello, Washington, next to City Hall. And their services they provide for the at the Federal Courthouse in Richland, Washington on Lee Street. And their services right across the street of the Federal Courthouse. Now, the docket number is 1760212, January 6, 2002, or January 6, 2020. James L. Dennis is the judge, area is criminal law. Petitioner sought review of BIA order dismissal of an appeal for IGS denial of motion for terminate removal proceedings and orders of removal. The Fifth Circuit held at the readjusting precludes the DHS from seeking to remove petitioner of the basis of this service. And this is docket number 1760212. This is the U.S. courts. U.S. courts for 10th Circuit. This is Ong versus King, docket 184082. January 6, 2020. Judge Mortz. Areas Law, Civil Procedure, Family Law, International Law. Japanese national Takagi Aga brought a Hague Convention against the former wife, South Korean national Kong, alleging that she was wrongly removed from their twin daughters from Japan to the United States. In violation of these rights of custody, seeking an order required the twins return to Japan. The district court disagreed and denied Antagon's petition, concluded that the twins' removal in the United States did not violate Ong's rights of custody or alternatives. Even the removal was wrongful. Even so, was wrongful. The removal was wrong. Twins objected to returning to Japan, appealed after review. 10th Circuit appeals. Pre-facia, showing they had rights of custody, conviction defined them. Accordingly affirmed district court's order. U.S. Court of Appeals, Federal Circuit, Karbreska versus Secretary of Health and Human Resources, docket number 191423, January 6, 2020. Judge Jimmy V. Reyna. Now, Jimmy V. Reyna, Judge, Area of Law, Health Law, Medical Malpractice, Public Benefits. The Karbreska sought compensation under National Vacancy Injury Act 42 U.S.C. Allegedly, the vaccination administered to their son aggravated to an underlying disorder caused him to suffer immune system dysfunction and other medical terms. They submitted 1,500 pages of medical records, medical lectures, affidavit report, 3 medical experts, the government substitute reports, preferable to the hearing, express serious misgivings about claim substantive validity, that the parties proceed a hearing unlikely to confiscate Karbreska's cause. Karbreska chose to forego a hearing, objected to the ruling of the record. Master allowed the parties to submit final briefs determining nothing in the record and expert reports suggesting the outcome different of hearing. U.S. Court of Appeals, 11th Circuit. U.S. Commodity Futures Trading Commissioners versus Wsfb. Docket 1616544, 1616544, docket 1911027, January 6, 2020. Judge Per Curum, Percurim. Judge Curum. Areas of Law of Civil Procedure. The case involved enforcement judgment. The CFTC obtained against defendant, which, among others, ordered defendant to pay $1,543,892,000 within 10 days of restitution and investors who fell victim to this commodity fraud sham. 11th Circuit vacated District Court contempt jurisdiction and modification of restitution provisions of this judgment, holding those provisions constitutions of money judgment enforcement under Federal Debt Collection Procedure Act that in the District Court civil contempt power therefore need to consider defendant's argument that the District Court consider exempt assets of defendant's wife, income determination of defendant's ability to pay. United States versus Oliver, docket number 1715565, January 6, 2020. Judge Charles R. Wilson. Area of Law of Criminal Law, 11th Circuit reserved. reversed defendant's sentence imposed after he pled guilty of possessing a firearm ammunition as convicted. The court held him defendant prior Georgia conviction making terrorist threats under OCGA 16-11-37A. 2010 is a predict violent felony under the Elements Clause of Arms Career Criminal Act. Court held because Section 171137A, invisible and abroad, under Mathis versus United States 136, S. Cincinnati 2243-2249, 2016. A violation of statute of character does Constitution predict offense under Elements Clause correlating to the court recommended resentencing. California Courts of Appeal, Del Sadro versus Mitchell, docket number B293472, Second Appellate District, January 3rd, 2020. Judge Tricia A. Bigelow, Area of Law, Civil Procedure, Legal Ethics. Plaintiff of counsel appealed post-judgment under denying plaintiff's motion. Production documents imposed $3,456.70 and sanctioned against counsel of discovery